Hello friends, in this video I am going to discuss what is voidable marriage. In legal term, the literal meaning of voidable is capable of being adjudged as void or annulled. Therefore, the meaning of voidable marriage is it can be declared as void based on the facts and circumstances by the court. Otherwise, it is a valid marriage. So in this video, I will discuss the meaning of voidable marriage. Let's start with the first question, that is, what is the meaning of voidable marriage? Unlike void marriage, which is illegal ab initio, that is from the beginning itself, voidable marriage is a valid marriage until it is proved void by the court. Likewise, if no claim is made and no case is filed to prove a marriage void, then such marriage is valid and accepted. Now, the next question is, what is the definition of voidable marriage? As per the section 12 of the Hindu Marriage Act, any marriage solemnized whether before or after the commencement of this act shall be voidable and may be annulled by a decree of nullity. Now, the next question is, what are the grounds on which a marriage can be annulled by a decree? Following are the significant grounds on which a marriage can be proved voidable. That the marriage has not been consummated owing to the impotency of the respondent. If the respondent is proved impotent and incapable to produce children, such marriage is voidable. Or that the consent of the petitioner or where the consent of the guardian in marriage of the petitioner was obtained by force or by fraud. If the petitioner didn't give his or her consent on his or her own, rather he or she has been cheated, lied, or threatened for such marriage, then this marriage is voidable. Or that the respondent was at the time of the marriage pregnant by some person other than the petitioner. So, based on any of the grounds discussed above, a marriage can be declared as void. Now, let's check out some of the limitations. However, because of certain facts and circumstances, a marriage can be annulled or declared as void. But even for this, there are certain limitations. That is, the petition is presented more than 1 year after the force had ceased to operate, or, as the case may be, the fraud had been discovered. It means petitioner needs to file such case within 1 year of the time. Such time is calculated either from the time of incident or from the time when such fraud had been discovered. That is, petitioner came to know about such fraud. So from that time to filing time, it won't be more than 1 year. Or the petitioner has, with his or her full consent, lived with the other party to the marriage as husband or wife after the force had ceased to operate, or as the case may be, the fraud had been discovered. It means even after knowing the facts, petitioner is still living with his or her spouse with his or her natural consent. In such a case, marriage is valid. Or that the petitioner was at the time of the marriage ignorant of the facts alleged. It means if the petitioner, in spite of knowing the facts, has ignored the facts during the marriage, such marriage is valid. Or that proceedings have been instituted in the case of a marriage solemnized before the commencement of this act, within 1 year of such commencement, and in the case of marriages solemnized after such commencement, within 1 year from the date of the marriage, or that marital intercourse with the consent of the petitioner has taken place since the discovery of the petitioner of the existence of the said crime. Now, the next question is, who can declare a marriage void? It is only the district court that, based on given facts, evidence, and circumstances, can declare a marriage void. Now, the next question is, who can file the petition to declare a marriage void? Normally, the aggrieved party, that may be wife or husband, can file such petition. Now, the next question is, where to file the petition to get the marriage annulled or void? Such petition is filed in the district court located nearby the residence of aggrieved party. Last but not the least, that is, what is the status of children from void or voidable marriage? As per the section 16 of the Hindu Marriage Act 1955, the children born from void or voidable marriage are legitimate. So this is all about the voidable marriage.